That's 00791 FY, State of Michigan versus Timothy Dansby.
Yeah, people.
7446, standing in for the attorney of record, Defendant, and appearing on behalf of Mr. Timothy Dansby, who stands to my right. Mr. Dansby, can you please state your full name for the record?
Timothy Dansby.
All right, Mr. Dansby, we're back. Do you mind having Ms. Miller stand in for Mr. Gonick for today's hearing?
That's up to the court, I still reserve my right. I mentioned all of the previous hearings, but part of today's process has been going what it's going to continue doing what it's doing, but I still.
Does that mean you don't mind her standing in?
One interpret.
The hearing begins with the judge trying to settle a very basic issue before anything else can move forward. The court simply wants to know whether Timothy Dansby agrees to have the substitute attorney appear on his behalf. Instead of giving a direct yes or no answer, he starts talking about concerns he has already raised in previous hearings. Right away, you can feel the judge's patience being tested. A question this simple shouldn't become a debate, but that's exactly where things begin to head. Sometimes, refusing to answer a straightforward question can end up creating much bigger problems than the original issue itself.
Okay, you know what? I'm not going to play that game. That's a yes or no question. Okay, do you want to adjourn it and see who it is? You have a right to have the counsel of record present if you want to be here instead of Miss Miller. And this is basically for a probable cause conference and adjourn date on a retail fraud first degree. When we had adjourned it before for your lawyers to get video discovery. So do you mind her standing in or no? Okay, so you don't want a lawyer, sir? I'll release him if you don't want one. Nobody's gonna force you to have a lawyer to help you. If you want to do it all yourself, do it. Do you want me to release the lawyers?
The judge makes it clear that Mr. Dansby has every right to have his attorney present, but he also has the right to represent himself if that's truly what he wants. The problem is that the defendant continues avoiding a direct answer. The judge repeatedly asks the same question, hoping to move the hearing forward. This creates a tense courtroom atmosphere because everyone knows that an unclear answer can have serious legal consequences. Was the defendant trying to make a point, or was he unintentionally making things worse for himself? What would you have done in this situation?
Do you want a lawyer? Yes or no? It's a real easy question, sir. It don't take all day. Listen here. Okay, if you don't answer the question, I'm going to release the lawyers. If that's what, because you've been complaining the whole time about, I didn't ask for no state attorney. I don't want to, I don't know what it, whatever you going to do. No, I'm not doing anything. I didn't appoint the person in the first place. I didn't do it. Okay, so you don't want them? Is that what you're telling me? Do you want them? Yes or no?
On the same.
Sir, listen, this is not going to be a matter of semantics. Do you want one or not? Because nobody's going to force a lawyer on you. I'll be happy to handle this case with you by yourself, doing whatever you can do to help yourself. If that's what you want.
I still didn't get my discovery, so.
So, do you want a lawyer?
I'm sorry, I'm still on the same thing.
I don't even know what that is. Whatever your claim is, I don't know.
Now, the frustration becomes impossible to ignore. The judge warns that if Mr. Dansby keeps refusing to answer, the attorneys will be released from the case. Even after hearing that warning several times, the defendant continues bringing up unrelated concerns instead of responding directly. The judge insists that nobody is forcing legal representation on him, but the choice has to be made. This is one of those courtroom moments where communication completely breaks down. Both sides are talking, yet neither side is truly getting through to the other.
Okay, let's release the lawyers. All right. Now, you're not getting another one. I'm just telling you.
I reserve the right for judiciary finding on the legitimacy of the court.
You're not getting another lawyer, okay?
Oh, yeah, I said
I don't know what you can reserve what you want. I don't mind.
finding the other court and the legitimacy of the court as far as the
Sir, whatever you want to do, you can do. But since you don't want a lawyer, I can't by law give you one. So,
That was three Germans ago.
guess what? So,
Lord have you given me the things that I need.
okay, sir, nobody can give you anything but a piece of paper. They can give you that. They could give you the police report. They cannot give you the videos because there's no way for you to watch them.
After several unanswered opportunities, the judge finally reaches a decision and orders the attorneys to be released. The warning becomes reality. Even then, Mr. Dansby continues raising objections about the legitimacy of the court and says he still hasn't received his discovery. The judge responds firmly, explaining that the court cannot appoint another attorney if the defendant refuses one. This is a dramatic turning point because a decision that could have been avoided with a simple answer has now become official.
Make sure that the law library at the court, it will order that the law library at the court either have a clerk or somebody to present the information for me to see the video. I don't know. Maybe you just don't want to get done.
Sir, I don't even know. I don't know anything about your law library wherever. All I know is these video files, they're files. They come on a computer.
So, the law library should somebody to be giving people at the law library a heads up to make it.
Well, you know what? That's up to you to figure out how you gonna get them.
I'll let the second circuit figure it out. Second circuit figure it. You know, probably judge, second court, Supreme Court, we can let them figure it out. I'm straight. Well, I ain't doing that.
Ready for me to take them?
Your Honor, would you like, Mr. Donovan to file any sort of motion or
No,
order to have him withdraw?
no,
The discussion shifts toward discovery evidence. Mr. Dansby argues that he cannot properly prepare because he hasn't been able to view the video evidence. The judge explains that the issue isn't about withholding evidence, but about the practical difficulty of providing digital video files to someone in custody. It's a reminder that legal procedures often involve logistical challenges, not just legal arguments. Still, from the defendant's perspective, not seeing the evidence naturally raises concerns about fairness. Do you think the system should have a better way to ensure defendants can easily review digital evidence?
write an order out right now, releasing him. And so we will reset this, I guess. I don't know why we got him. We could actually bring him back out and he could decide what he wants to do today.
I do know that, he is wanting to have his preliminary examination. That is.
Okay, well, let's set it for an exam then. How many witnesses, Mrs. Shockley?
Probably just me one.
All right. You want to wait for your order? You can.
Okay, thank you. One witness.
Right.
Yeah, one witness and one defendant that's gonna make it way longer than it's supposed to be. So factor that in.
With the attorney issue resolved, the court turns its attention to scheduling the preliminary examination. The judge asks how many witnesses will testify, and the prosecutor indicates that only one witness is expected. Even in this procedural discussion, the judge notes that having one witness and one self-represented defendant could make the hearing take much longer than usual. Representing yourself in court may sound like a way to stay in control, but it often makes an already complicated legal process even more difficult.
Court's available October 3rd at 10:30.
All right. So October 3rd at 10:30. Is the exam date. And could you ask Mr. Gonick to make sure he gets a discovery, what he has? over to this person.
I believe that paper discovery has already been given to him. I'll see if the court or if the jail will allow us to give any sort of drive or anything like that that encloses the videos.
This record, I would advise the court, the discovery, the AV discovery in this matter is 99% police body worn camera, which has the defendant in it, and there's only one.
The preliminary examination is officially scheduled for October 3rd at 10:30. Before ending the hearing, the judge instructs the prosecution to make every reasonable effort to ensure Mr. Dansby receives and can review the available discovery. The prosecutor explains that most of the evidence consists of police body camera footage, along with one store surveillance video showing the defendant walking by. This exchange shows that despite the earlier conflict, the court still wants the discovery process to move forward properly.
In-store video of the defendant walking past that. So. You
Okay.
didn't know what.
Okay. Well, good. Just make sure he sees it. Just some of your best efforts on that. And here's the order.
As the hearing concludes, the judge once again emphasizes that Mr. Dansby should be given the opportunity to review the evidence before the next court date. The written order releasing the attorney is finalized, closing this chapter of the case. What began as a simple procedural hearing turned into an important lesson about how critical clear communication is inside a courtroom. A single unanswered question changed the direction of the entire hearing. This hearing focused primarily on legal representation and discovery rather than the underlying criminal allegations. The judge repeatedly gave Timothy Dansby opportunities to clearly state whether he wanted legal counsel. Because he never provided a direct answer, the court ultimately released his appointed attorneys and ruled that another attorney would not be appointed. The hearing then shifted toward ensuring discovery materials, particularly police body camera footage, would be made available before the scheduled preliminary examination on October 3rd. The broader takeaway is that courtroom procedure depends heavily on direct communication. Even when someone has legitimate concerns, failing to clearly answer the court's questions can significantly affect the course of a case. What do you think about this courtroom exchange? Did the judge show enough patience? Or should the defendant have been given even more opportunities before losing his attorney? Share your thoughts in the comments below. We'd love to hear your perspective. If you enjoy real courtroom breakdowns and legal analysis like this, don't forget to like the video, subscribe to the channel, and turn on notifications so you never miss our next courtroom case.